Now let's get some more perspective on this matter, and we're being joined live from Abuja by a senior advocate of Nigeria and Vice Chancellor of Bayes University, Abuja, Professor Maman Tahil. Glad to have you join us.
Thank you. It's a pleasure to be with you.
Now, how would you react to the judgment by the British court giving the go-ahead to P&ID to seize Nigerian assets?
Okay, yeah. Okay. Thank you. This is a very delicate and problematic case for Nigeria, given the volume of money involved and the efficiency of the judicial process in the United Kingdom, unlike Nigeria. Now, but obviously, as the Solicitor General mentioned, this is the first level of the courts. And so what is expected is for the Nigerian government to challenge that decision as quickly as possible at the appeal level and then apply for a stay so as to ensure that it doesn't face the kind of, because we are talking about the danger we are talking about, because $9 billion is not a small money. And the judicial process there too, as we said, doesn't stay long. So even the appellate stage may not last too long because of the interest that may arise on the judgment, in the matter. And so the government has to vigorously pursue the appeal and apply for a stay.
Well, Professor Tahil, does the federal government have any chance of reversing this judgment?
Yes, in any trial, there's always a chance, there's always a possibility. And the only thing to do is to act in good time. And obviously, nobody will sit back and watch its assets, seized, especially given the amount of money, as I said, and the kind of, they would want to move as quickly as possible. And that's why the federal government of Nigeria have to act swiftly, to pursue its appellate rights, and then, apply for a stay of the enforcement of the judgment itself. And, that's why in a very general way, the government of Nigeria has to be much more careful in handling transactions involving international companies, because from the reports given, this is a company that was just starting business in Nigeria. And, and then even also looking at the terms of the award and the judgment itself, it covers the entire period of the contract, 20 years, and without the company putting in anything at all, although it claims to have spent about $40 million on preliminary matters, and to now go away with $9 billion, I mean, I can't think of any such a lucrative business like this. So that's why the government needs to challenge this with the most vigor and have the best legal teams available who are versed in international transactions, and probably a team of lawyers over there and teams from Nigeria to ensure that we don't take chances at all.
Going forward now, Prof, what are the lessons Nigeria can learn from this?
Greater diligence. This is just the main thing. Greater due diligence in entering into contracts with international firms. Because to me, it sounds quite like, if I may use the word, a bit of an insult, actually, for a firm to simply invest $40 million and expect to walk away with $6 billion initially. That was the initial award. And now, because of interest and other charges, going to 9 billion and increasing until the time the matter is settled finally. So the government of Nigeria, especially in oil transactions and all transactions for that matter, need to be extremely diligent in its negotiations, in the legal, covering all the legal tracks. And then even vetting carefully the companies it goes into contract with.
Professor Maman Tahir, it was a pleasure having you with us on the News at 10.